Okay, there we go. Okay, Alice, so we can start now. So welcome to everyone and thank you for joining us today. I know it's been very difficult for some of you to get here with load shedding and connections crashing, and let's just get to December already. It seems it's that time of year. So thank you for joining us today. I'm going to hand over to Alice Brown from probono.org, and she will just be giving an overview of the project.
Hi, good morning, everyone, and thank you for working your way through the problems and difficulties we are all having between ESCOM and City Power and the various powers that be. I am also having trouble where I am, so I may be able to stay connected or I may leave you sooner than what I would want. But my name is Alice Brown, and I work with probono.org on this special project. This morning's webinar is focused on instituting an unfair discrimination claim under the Employment Equity Act. And this webinar is part of a series of webinars that probono.org has organized with support from the AIDS Foundation of South Africa, or AFSA, and the Global Fund to Fight AIDS, TB, and Malaria. Through this program, Pro Bono has been tasked with trying to get more legal practitioners to do pro bono work focused on the needs of key and vulnerable populations affected by HIV/AIDS and TB. Those key and vulnerable populations include people living with HIV/AIDS, people living with TB, people who use drugs, sex workers, people with disability, children, adolescent girls and boys, those and people who have been victims of gender-based violence. Those are some of the key and vulnerable populations that this program focuses on. We are looking to get, like I said, more legal practitioners involved in pro bono activities with these key and vulnerable populations. And with that in mind, we've organized a series of webinars over the course of the last year and a half or so, focused on the legal issues facing those populations. So with that in mind, we have invited Mr. Goldberg to give this webinar, and we appreciate him taking the time out of what I'm sure is a very busy schedule to do this. And we hope that this will generate an interest in doing more pro bono work on behalf of these folk who are particularly in need of legal services. So thank you very much. I hope that I get to stay with you for the entire seminar. But if I don't, know that I am here in spirit. Thank you.
Thank you, Alice. So yes, we can kick off now with the webinar. So throughout the year, while we've been presenting these webinars, as well as the research that we conducted, we found that there is still quite a bit of discrimination in the workplace for employees who have HIV/AIDS and TB. So some of the webinars have looked at more of the substantive issues. So what does discrimination look like and what does the law say? And we decided that we wanted to have a more of a practical webinar so that lawyers can be prepared to draft discrimination claims under the Employment Equity Act. And so we're hoping that this will be more practical. Andrew Goldberg is a renowned labor lawyer. I have seen him many times at the Labour Court, and I can tell you there's not an attorney who doesn't know Andrew Goldberg in terms of labour law. So we are very excited to have Andrew here. And as Alice said, he's very busy and he's made time for us today. So without further ado, Andrew, I'll hand over to you.
Andrew, you're muted.
Andrew, you're on mute.
There we go.
Oh, there we
right.
go. There we go.
Right. Okay, cool. Can everybody see my slides?
Yes.
Great. Okay, so welcome. Thank you for hosting me on this probono.org webinar, I'm going to be talking about legal drafting and discrimination. Let's kick right off. Okay, my name is Andrew Goldberg. I've been an employment lawyer for 17 years, got a master's degree in labor law. I've spent time as an acting judge at the Labour Court, and I've appeared thousands of times in the Labour Court. I've also appeared in the Labour Appeal Court and other courses. I've done disciplinary hearings and a few other things. Okay, let's look at drafting of pleadings. Pleadings are very, very difficult to draft. I think that people need to understand that drafting of pleadings starts right from the time that you meet the clients. That is the most essential part of the whole operation. I'll go into that a bit later as to how you meet the client, what you need to ask the clients, and what you need to get from the clients in order to be able to draft the papers. Okay, what is workplace discrimination? Now, a lot of people don't understand what the word discrimination is, because discrimination actually is not an unfair term by itself. Discrimination can be said to be fair or unfair. In South Africa, we only look at unfair discrimination. In South Africa, we've got quite a few different kinds of acts. We've got the Employment Equity Act, we've got the Labour Relations Act, we've got other acts that list what is fair and what's unfair, including the Constitution itself. Now, in South Africa, we've got listed grounds and unlisted grounds of discrimination. Where a ground falls within the listed grounds, then it's said to be that there is discrimination, and then the employer needs to prove that such discrimination or differentiation is fair. Where the ground does not fall within the listed grounds, then discrimination needs to be proven, and the onus on the employee or employees to prove that there was discrimination, and then only does the onus shift to the employer to prove that the discrimination was fair or justifiable. Now, a lot of people have said that onus is not that important, and I agree with them, because what the next case will show, and I'm going to show a case now, is that on the unlisted grounds of discrimination, there are very low hopes of winning at Labour Court or in any forum in this country, because the listed grounds have set out exactly what needs to be provided, whereas the unlisted grounds, you'd have to prove that there is discrimination. Now, how would you go about proving that there's discrimination when it isn't on a listed grounds? You'd have to show that that discrimination is inherently discrimination. In other words, it's arbitrary, but it allows for discrimination in every sphere that it applies. Okay, let's look at the Employment Equity Act. The Employment Equity Act lists several grounds of discrimination. They're race, gender, sex, pregnancy, marital sex, family responsibility, ethnic or social origin, color, sexual orientation, age, disability, religion, HIV status, conscience, belief, political opinion, culture, language, birth, or any other arbitrary ground. Now, the arbitrary grounds are the unlisted grounds. So they list more than 10 grounds. And I don't think that if you want to bring a case at the Labour Court or at arbitration, you'd have to list your matter or link your matter to one of these grounds. Without linking it to one of these grounds, I don't believe you've got a chance. Section 6.4 specifically recognizes that a difference in terms and conditions of employment, directly or indirectly based on any one or more of the grounds listed in Section 6.1 between employees of the same employer performing the same or substantially the same work or work of equal value constitutes unfair discrimination. So if you list it to one of these grounds, it's already presumed that there is unfair discrimination. And then from there, you can draft your papers. Let's look at a case where somebody used arbitrary grounds. The case of L. Koi, I hope I'm pronouncing it right, and 220 others versus Metrotel Prasa. Here in this matter, what the employees were complaining about is that they had a choice whether they could join the medical aid or not. And those people who joined the medical aid got a subsidy of 350 Rand, I think it was. 356 Rand. So they got a subsidy of 356 Rand, but the problem was that the 356 Rand didn't cover for the entire amount. So therefore, they had to get use some of their salaries in order to substitute the remaining amount. And therefore, when one looked at the salaries, some people received less salary than other people who were not joined to the medical aid. Then there was a whole list of promotion and the like, and that's not really that relevant, but eventually what happened was that they launched a case at the Labour Court, which said that they were getting less money, and therefore there was differentiation, and therefore there's discrimination. The Labour Court looked at the test for proving discrimination on arbitrary grounds as set out in Section 9.2 of the Employment Equity Act. Prior to the complaint, allegedly unfair discrimination must prove on a balance of probabilities that the conduct complained of is not rational, the conduct complained of amounts to discrimination, and discrimination is unfair. So they have to prove 3 new grounds. Additionally, the Regulation 3 of the Employment Equity Act regulation provides that in order to eliminate unfair discrimination, employer must take steps to eliminate differences in terms and conditions of employment, including remuneration of employees who perform work of equal value if those differences are directly or indirectly based on a listed ground or any arbitrary grounds that is prohibited by Section 6(1). Now, we don't have to look at Regulation 7, but what the Labour Court then dealt with was each category of the people. Firstly, the differentiation based on medical subsidies. The Labour Court recognized that those employees who had not opted for the medical aid scheme might appear to be in a more favorable gross financial position. However, it was held that this differentiation was rationalized when considering nation has had the financial burden of having to carry the cost of any medical expenses the employees would have had otherwise been covered, or had they chosen the option which would have given them less gross remuneration. Additionally, the cost of bearing this financial burden will vary depending on the medical insurer and the health of the individual employee and their family.
Sorry, Andrew, are you able to change the slides?
Yes.
Okay.
So here, the Labour Court also looked at the issue of promotion and the like. And what happened there was that it wasn't really that important, the promotion part. The important point is the medical aid subsidies. So here they actually found that the medical aid subsidies, even though it reduced their salary, was a benefit to the employee. And this also doesn't really have relevance, so we can move on to the next slide. And all the slides will be available to everybody. So the case shows that although Section 6(1) of the Employment Act prohibits unfair discrimination on an arbitrary ground, the ground considered to be arbitrary should still be sufficiently similar to the expressly listed grounds, because the claim for unfair discrimination cannot be based solely on an arbitrary ground and must at least be linked to a listed ground. That's quite upsetting for a lot of people because they don't find that health, which is what we're going to be talking a lot about today, is a listed ground. So let's look at how to do a consultation with people. So once you get your clients in front of you in a consultation, it's very important that you get all the facts from them, because without all the facts, you cannot draft the matter. And later on, you cannot maybe call the client, they maybe live in an area which they cannot get hold of, and you need to obtain all the facts from them. So you need to obtain and absorb all of the facts that are relevant to the dispute, and that will assist the judge in resolving the issues. You mustn't think of yourself as the person who's inquiring. You must think of what the judge will be wanting to hear in this matter. The judge is the consumer of the law. You are the salesman of the law. So you need to sell the law to the judge. These facts must be supported by credible evidence. The client's version of the evidence must be plausible and supported by undisputed facts and available evidence. Important test is to say to yourself, when the client has finished consultation with you, do you believe the version of your client? If you do not believe the version, do not do the case. It's a simple test. You cannot do a case that you do not believe in. That's against the law, against your ethics, against your oath as a lawyer. If you are a human resource practitioner or anybody else in that regard, you don't have an oath, but you should not do cases that you do not believe in. You need to understand that the Labour Court doesn't want to hear cases that have got no merit. And it's clear when you are a judge of the Labour Court, you see which cases don't have merit. Those are the ones that run into hundreds of pages. Claims of statement are extensive and do not cover what the dispute is about. You read the papers and there's actually no idea what the dispute's about. And what's more is often the lady or the man who's the individual, the client, your client whose case it is, doesn't set out what they are actually claiming. Because you need to set out exactly in your papers what you're claiming. You must claim both unfair discrimination and damages. Now, damages needs to be specifically pointed out. So let's look at step 2. Identify, rank, and test disputes of fact and disputes of law. Once you've obtained all of the facts, you need to determine what issues or disputes arise from these. Identify disputes of fact and disputes of law. Rank these in order of importance, dealing with the most important one first. Test the issues, refer back to your clients, and be sure that the manner in which you both interpret these disputes aligns. In other words, you must be able to speak like the client speaks. When the client tells you her story, you must be able to tell her story to her. Okay, let's contextualize the issues. Point 3. You now know the facts, you've worked out the legal issues. Now found the law. Establish the applicable area of the law and then contextualize the issues. Your job now is to correctly identify and understand the law, explaining it before you can apply it to the facts of your case. If there are any questions, you can put them in the sidebar and then I'll answer them at the end. Okay, step 4, understanding the law. The next step in the process to gain understanding of the applicable legislation, here you'd be the Employment Equity Act or the Labour Relations Act, and the leading cases pertaining to the issue at hand. Obviously, you would have now finished your consultation with your client, and now you'll be moving on to start drafting the papers. And you'll need to understand the law and what you're doing. And you can't charge the client for not understanding the law. You as a practitioner should understand the law. You must be able to cross-reference every legal reason with the law or the legal authority. Write a short chapter summarizing the rule in your own words to help you focus and test your understanding of the rule. Step 5, applying the law to the facts. Legal rules have distinct legal elements within them, which must be proved for the rule to be applicable to the facts of your case. The strength of your case is determined by how well you can satisfy each element based on the material facts of your case. Thus, you'll need to have a thorough knowledge of the facts of your case. Number 6, and most important, because without the relief and without the conclusion, you have got no case. Your conclusion must be supported by the facts of your case and by a legal rule. The best place to find support for legal rules in the most recent decisions of the highest court. You don't need to present more than one decision. And that's very important. You only need to find one case that is similar to your case and one idea that's similar to your case. You don't need to put in thousands of different cases and the like. And in even particular claim, you shouldn't actually put case law. You should put ideas, legal issues, and what you want. You shouldn't actually put case law. So if you want to use a case, rather use the idea of the case than the actual case itself. Right, so what is writing pleadings about? And this is written by Advocate Hussein, who's a former judge of the High Court and Competition Appeal Court. He says writing is about thinking. When you use a precedent, you don't think. When you write, you're writing for the judge who needs to know what the case is about, and for the other side who wants to know what your claim or defense is. Copying and pasting from precedent will not result in persuasive arguments for your case. We need to change, we need to resolve disputes, listen to our clients and cooperate with our opponents. Good drafting is not only about writing technique and skill. Good drafting is about what you write. And I think that I read this the other day and I thought to myself, wow, this is the best 5 points or 6 points I've ever seen. Writing is about thinking about the matter, about getting across what you need to get across only. Keep your pleading short, to the point. What do you want? So what is the case about? What do you want? What law is applicable? And then finish it off, conclude. Okay, so this is another slide which I've managed to get out about consultation. You must understand the client's issues. Clear communication between yourself and the client. Create a timeline of all necessary events. In other words, set out on an Excel spreadsheet, on a piece of paper, what happened first, what happened second, what happened third, and what led to the actual discrimination. What is the result that they seek? How do you get to that result? What are the damages and the like? Use the available resources, case law, precedents, colleagues, and counsel, as well as the internet. In other words, you sitting in your office cannot come up with ideas. You need to speak to colleagues, other lawyers, and the like. I'm always available, and a lot of attorneys phone me and ask me questions, and I give them advice, and they give me advice. And it's a give and take process. And that's why it's very good to become friendly with a counsel or an attorney who knows the law better than you do, or even one that doesn't know the law better than you, but actually practices the law more than you do. So practicing of the law is different from actual reading of the law. So it's very important to have friends in all areas. Okay, let's look at the case of McClungu versus Saman Corp Chrome. And this will be quite an extensive case that I'm going to be dealing through these slides with. Now, this case came before the arbitration way back in 2015, after the employee went on maternity leave. So here, Saman Corp had a policy in place of maternity leave. The employee was an underground heavy-duty truck driver. She fell pregnant, and then she was forced to take what's called leave because she was working in a hazardous area. And either they could find a job for her, or they couldn't find a job for her. And once they couldn't find an alternative job for her in a non-hazardous area, they put her on leave. Now, the employment maternity leave was from 29th of November 2014, and she was placed on leave, paid leave before that for 5 months, from the 4th of June 2014 to the 28th of November 2014. The company set out that this was because it was unable to find her a suitable alternative position. The employee took issue with the fact that she was the only pregnant employee out of 18 employees who was not offered alternative employment by the respondent before her maternity leave commenced. The policy was the following. So in twofold, it was provided for unpaid maternity leave if the employee fell pregnant in the first year of employment, or if the employee falls pregnant twice within a 3-year circle. So if that was the case, you would not get maternity leave. All other employees were paid maternity leave. Also, where you worked in a hazardous area, where there were no alternatives that could be found for those pregnant employees working in hazardous areas, these employees were put on unpaid leave. Looking at the next slide. What happened at arbitration? The matter referred to arbitration. Obviously, at arbitration, you don't have a statement of case. But what you, yes?
Andrew, just to let you know, your slides are not moving. We're still on slide number 1.
Oh, wow. Then move them along. Okay, let me go with that one. I think I'm not sharing.
There you go.
Are they there now? Are they there now?
Yes, they're moving now.
Yes, now.
What slide am I up to now?
You're on slide 17. 21, sorry, 21.
Okay. Let me just move this. Let me move it this way. Okay, right. I'm now on slide 3. What slide am I on now?
3.
Okay, great.
Drafting of pleadings.
Okay, there, can you see that slide now? What slide am I on now?
Drafting of pleadings.
Now.
Okay, great. Now they're moving. Okay, so this is what is workplace law. Okay, here's the Employment Equity Act. There are the grounds, there are listed grounds. Here's the case law, regards to El Khoury and 220 others versus Metro Rail. And there's a differentiation complaint of the employment subsidy of 356 Rand per month. There's the labor court evaluation, and all these slides will be available, so don't worry about that. And there's the differentiation based on medical aid subsidies. And that's the quote that I quoted earlier on. And there's the consultation advice.
Sorry, and
get the
slides
facts.
still aren't moving.
Aren't they moving?
No.
Okay. Now?
Still not. There we go. Okay, so now we're on slide 13.
Okay, so can you see the whole slide though?
Yes.
Okay, great. So there's a case there. Okay, there's a case. Okay, great. Okay, cool. So I'll leave it like this. That's perfect. Wonderful. Okay, so get the facts, identify, rank, and test disputes of facts and disputes of law, contextualize the issues. Point 4, understand the law. 5, apply the law to the facts. And 6, reach a conclusion. And here are the 6 quotes from Advocate Hussain that I read out earlier. And then here's another slide on how to do consultations. And then we now move on to the case law. Has everybody got the case law in front of them? Okay, great. So let's move on to this. The mine had 2 different types of policies. Provided for unpaid maternity leave if the employee fell pregnant in the first year of employment, or if the employee falls pregnant twice within a 3rd year cycle. Where no alternative could be found for those pregnant employees working in hazardous areas, these employees were put on forced unpaid leave, actually. Right, so at arbitration, the issue in dispute was whether the company, by failing to find alternative employment for the employee, had discriminated. The mine testified first. They led their first witness. The mine witness testified that the reason why the employee had not been placed, I should say, in an alternative position and had been forced to go on sick leave was because the mine had not managed to find a position for her. She said that the document which set out the reason for her being placed on leave was that she had fallen pregnant twice within a 3-year period, related to the maternity leave not being paid and not to the leave itself, and that the word maternity had been left out in error. So what she said is that the reason that the person was not paid maternity leave was because of the actual fact that she could not find a job, not the issue of the maternity leave policy itself. She did concede that another employee had fallen pregnant less than 2 weeks later, had been placed in an alternative position. The employee then testified to the fact that she had been informed by another HR officer that the reason as to why she had not been placed was because she had been fallen pregnant twice within a 3-year period. The commissioner found that the mine had discriminated against the employee and awarded her 20,000 in damages because she was forced to be on leave for 5 months. He found that the mine's maternity leave policy was problematic, ordered that it must be reviewed or amended, and to remove any possible discriminatory effects, and he found that she was to be paid compensation for the time period that she was forced to be on leave because the mine had invoked its maternity policy. So in other words, the commissioner found that she was forced to go on leave, and that was discriminatory. Then the matter went on appeal to the Labour Court, and the Mines Council was Ms. Gugu Matlani of Solomon Homes, and the heads of argument were drafted by Anton Marburg, senior counsel, and Riaz Itkin. The representative for the mine argued that the employee never sought any damages. In other words, when the arbitration started, the commissioner had not asked her what she actually wanted, and she hadn't said anything about damages at all. All she claimed was that she was unfairly discriminated. We also found that they also argued that the commissioner had acted ultra vires in ordering the company to amend its maternity policy, because that had never been an issue. And never mind that he didn't have the power to force them to change their maternity policy. Further, he found that there had been no discrimination. In respect of the discrimination issue, he based his argument on 3 points. First one, the mine had clearly not placed the employee on unpaid leave because she had fallen pregnant twice in a 3-year period. This version had not been put to the mine's witness, and what is more, the maternity policy was irrelevant. Further, if there was anything that the mine had done wrong, it was not placing the employee in an alternative position when one arose, and that this was not discrimination. The union, who was represented by Mr. McIntyre, of McIntyre attorneys, and the heads were drafted by P.L. Mokwena, senior counsel, and M.Z. Makoti, argued that the employee had been discriminated against the employee in that it had forced her to go on leave because she had fallen pregnant twice within a 3-year period. Now, the court heard the late Judge Zenkamp, who passed away, funny enough, from a rattlesnake. He was away on holiday and a rattlesnake bit him, and he passed away from that. He was an amazing, amazing judge who I knew personally. And such a freak accident. He was away by himself on his motorbike and used to go on these trips to the Kalahari, and he got bitten by a snake. So he was an unbelievably fair judge and always really very well acute with the labor law system and the way the labor works. And he found out that there was no discrimination. He found the most important part of the Employment Equity Act to be looked at was Section 11, and in particular Section 11(1)(b). And I'll quote from the case. He says, before setting out at paragraph 16, the legal frame is important to understand the concepts of unpaid leave and maternity leave. In the context of Samankwa's leave policy, the pregnancy in the workplace procedure states as its objective to address the needs and protect both pregnant and lactating employees at Eastern Chrome Mine. Goes on to note that Section 26(1) of the Basic Employment Act prohibits an employee from requiring or permitting a pregnant employee or an employee who is breastfeeding to perform work in a hazardous area. So therefore, he found that this act that was looked at was quite fair because it stopped people who are pregnant or breastfeeding from operating in a hazardous area. He said that the employees in the bargaining unit are granted 4 months paid maternity leave wherever they are not on they've not been pregnant twice in a 3-year leave cycle, or they are not in their first year of work. Now, that's also fair because at least people are getting maternity leave. The employee therefore makes a decision between paid maternity leave, unpaid maternity leave, and unpaid leave granted as a result of the company not being able to find suitable alternative placement for a pregnant employee who otherwise works in the hazardous conditions. So he found that the policies themselves were not unfair. Here, the employee was placed on leave because she was working in a hazardous area and because they couldn't find her a place. It was not because she had been found to have been pregnant twice in a 3-year period. This is seen by the question when at the 22, when questioned by the commissioner, Ms. Dubie states that the reason why the employee went on unpaid leave from 4 June 20 November was because there was no alternative work where she could be accommodated. Mrs. Dubie actually drafted the document and she left out the word maternity. And the judge believed that this could be the only situation. In other words, it was not relevant that the 2-year and 3-year and 1 year, because that wasn't relevant to the leave of the employee. The leave was purely because she couldn't be found a place of employment. Okay, so then Ms. Maklangu on the other hand alleged that Ms. Mutlala had told her the reason why she was being sent on unpaid was because she had a second pregnancy in a 3-year cycle. But the actual pregnancy in this regard, the maternity leave policy, was not applicable. Ms. Mutlala points out an argument this version, the representative for the company said, had not been put to Ms. Dubie before the company had closed its case, only makes its appearance for the first time Ms. Maklangu's evidence in chief. In those circumstances, Ms. Maklangu's evidence on this point felt to be discarded by the commissioner. The judge then said, I agree with Ms. Matlana on the evidence before the arbitrator. The balance of probabilities weighed in favor of the company's case to the effect that Ms. Maklangu was placed on unpaid leave before the commencement of her maternity leave because an alternative position could not be identified for her, and not because of the second pregnancy in a 3-year cycle. Okay. And he found another 7 different problems with the judgment, sorry, the award of the commissioner, which I'm not really going to go into because they're not really that important. But you will get them when you get the slides. At 28.7, he found that the employee might have suffered humiliation, having to explain to her family and the community that the reason for her unforced leave was that she fell pregnant twice for a 3-year period. The employee, though, had led no such evidence. In other words, where you want to prove damages and the like, you need to lead evidence as regards to damages, how you suffered humiliation, how you suffered defamation, how you suffered damages. You cannot just assume that the commissioner can suck it from his thumb as to how you suffered, and you need to really, advance your case in this regard. Okay, then the judge concluded for all these reasons the appeal must succeed. Furthermore, the employee showed no differentiation between her and other non-pregnant employees. The reason why she was placed on unpaid leave was in accordance with the pregnancy policy and the Basic Conditions of Employment Act. The only difference she could point to was in the treatment of Ms. Manoche, the other individual who had got the job, who had been placed in an alternative position, and the reason for that treatment was explained by Mrs. Dube. There was a job available. The mine's representative at the case pointed out the decision of Impala Platinum versus Janasi, which had been decided in August 2017, where the judge, exactly the same judge, Mr. Steenkamp, had found that, Anton Steenkamp had found that the decision was not dissimilar. In that judgment, the same judge had set out at paragraph 15. In this case, the employees complained that they were treated differently from other pregnant employees. Yet the commissioner simply found that the company had discriminated against them because they were pregnant. The complaint, contrary to what the commissioner found, was negated by the comparator, being other pregnant women. So you need to you can't compare apples with apples. You need to compare apples with, let's say, pears. You can't compare pregnant women with other pregnant women. You have to compare pregnant women with other employees who are women or other employees who are men and women. The treatment of some pregnant women compared to other pregnant women simply cannot constitute discrimination based on pregnancy. They were not treated differently because they were pregnant. They were treated differently from other pregnant employees who were given alternative employment because they did not have the requisite skills. So here, some people had not got jobs because they didn't have the skills. And that was what the differentiation was. And differentiation on skills is not a recognized ground. So the union then sought to appeal the matter to the Labour Appeal Court. And the Labour Appeal Court took a completely different view of the matter. Acting Judge of Appeal, Judge Savage, with the other 2 judges concurring, found that because the mine had not placed the employee into an alternative position, this amounted to differentiation. And that such differentiation amounts to unfair discrimination. She set out that the mine had unfairly discriminated against the employee on the prohibited ground of pregnancy and awarded the employee's salary for the period she had been on forced unpaid leave. Now, for me, this decision is completely incorrect. Why is it incorrect? Definitely there was an unfairness, but for me, it was more unfair labor practice. In other words, when the employer is placed on leave because she didn't have a job, they couldn't find a job for her, what they should have done is they should have kept on investigating the matter. And when a job arose, given her that job. The next lady in the table, or the next lady to get pregnant, shouldn't have got the job. She should have got the job. And that's an unfair labor practice. But there was no discrimination. And that's why the decision from the Labour Appeal Court is wrong. And I was talking to Anthony Solomon from Solomon Homes just recently about this exact matter, and he agrees with me completely. He says that he told the mine that what they'd done was wrong and they shouldn't appeal the matter to the Constitutional Court because the Constitutional Court would probably find that it was an unfair labor practice, despite the fact that unfair labor practice was never ever referred. But here, as one can see, discrimination was only granted because it was linked to a listed ground of discrimination. So if one hadn't linked it to a listed ground of discrimination, in fact, it was an arbitrary ground of discrimination. And the arbitrary ground was that those people who at the time were available to get a job and the job was available were given a job, whereas others weren't. But that's not a listed ground. So therefore, one cannot grant such discrimination. There's no discrimination there. Okay, moving on to the next slide. I think I've finished actually my slides. And if there are any questions, if you could just post them in the right-hand side. I did want to look at more drafting and the like, but I think that's really sums up my talk. I don't know if everybody's got any questions that they'd like to ask.
Thanks, Andrew. Do we have any questions? I'll start with one in the meantime. When you were discussing bringing a case on arbitrary grounds, you mentioned the decision that said the arbitrary ground must somehow sort of be linked to the listed grounds. We've had previous conversations in these forums about how would one bring about a claim based on discrimination of TB, because TB is not a listed ground. And some have said it should come under disability, or we should bring it under a arbitrary ground. Now, I'd like to hear your views on that.
Well, it's the same as, let's say, any illness that an employee has, and I believe that TB is definitely an illness that an employee has, is a disability. I believe you have to link these grounds to some ground, listed ground, because otherwise the Labour Court won't even hear you. I mean, how are you going to prove that TB is by itself inherently discriminatory? It's not. It's just a condition that somebody has. Everybody has different conditions, and if things wrong with them, I might have glasses, and therefore I might be discriminated because of my glasses. But one will agree that that's not discrimination. It's not a listed ground of discrimination. If I wanted to bring a case for that I couldn't see properly, or that other people were seeing better than I was seeing, then I'd have to listen to an inability or a problem that I've got. And then I agree with you in that regard. You must look at issues like the problems with people, and you must link it to a ground of discrimination. You cannot leave it as an arbitrary ground. An arbitrary ground would definitely mean that you have to prove three separate things. And when it looks at my slides, the slides show that these three grounds that you need to prove are nearly impossible to prove. I looked through cases of the last 5 years in preparation for this webinar, and I could not find one case proven on an arbitrary ground. And that was over 300 cases that I looked at. Not one case was proven on arbitrary grounds.
And then, I mean, you're obviously in practice, and my experience is a lot of clients come in and they'll say things like, I know I'm not liked, and I think it's because of ABC reason, and it's one of the listed grounds, race or gender or sexual orientation. But then there's like no concrete proof. There's no email, there's no WhatsApp, there's no record of a conversation. But, it may be structural, right? Many institutions are inherently racist because they've been around and haven't changed for the last 50 years. Have you any advice on trying to prove, because we could also link it to the HIV/AIDS type of discrimination?
There was a case where a doctor working on horses in Pretoria was shown to have been fired because he had AIDS, and he was working on the horses, and he got 12 months. And that was proven on a kind of an arbitrary ground of discrimination. And that was way back in 2012. And the person only got 12 months. The TV was there and all the paraphernalia were there. And I was astonished. 12 months for being dismissed as a doctor, whereas, at least 24 months should have been the outcome. And, he was quite happy with 12 months, and the newspapers were going mad saying, wow, wow, wow. But he wasn't reinstated into his job. He got 12 months after being a doctor at the company for 20 years. 12 months. So for me, when you come in and people tell you that things are different, or that they believe that they're being treated differently because of their race or their gender or their sex or their religion, they need to have substantial proof of it. They need to have raised a grievance, a timeline grievance. Why I say a timeline grievance is if you raise a grievance and it's not timeline related, it's not worth anything. So you raise a grievance and you say to the company, you've got a month to get back to me to sort out this grievance. Then once the grievance is held, then you can say, well, what was the reason behind why I was treated differently? Because I was, let's say, a female, I wasn't given a promotion. And why the other two people who were males got promotions. And then you could find out what the true reason was behind the actual differentiation. Because what they are telling you about is a differentiation. What they're not telling you about is a discrimination. You need a discrimination. In order to come to court, you need a discrimination to prove that there was a total differentiation based on a listed ground. In other words, this differentiation is, anybody's got a difference. When I'm at work, I've got an office. Other people don't have an office. Other people are in the open area. That's a differentiation, but that's not discrimination. Discrimination needs to be proven let's say that person raised a grievance to me to say to me that they want their own office. Then I could justify to say that they're a junior employee, that they've only been there for 2 years, and therefore they're not entitled to their own office. And that wouldn't be seen to be discrimination. That is a differentiation. And obviously in life, there are going to be differentiations. But discrimination is one that's been proven at work. In other words, the employer comes and says, it's because you are a female that you didn't get promoted. Then you can take that to the labor court or to the CCMA. I had a matter where an individual was working at a company, a school. Her husband was working at the same school, Mrs. Else and Mr. Else. And Mrs. Else was working at the school, and she was wanting a job at the school in the hostel department. And the company said that, the school said that she couldn't get a job at the hostel department because there was already too many couples at the business. In other words, that there was really too many couples employed at the school. So therefore, she had to work elsewhere. She had to get another job. She had to get a car, travel between distances. And what's more is when we went to arbitration, the school said that they had discriminated against her. They agreed they had discriminated against her. And when we went to labor court, they then changed their tune. They wanted to say that they hadn't discriminated against her, but that there was already too many white people at the school. But that hadn't been pled in their papers at all. And what's more is that they brought their case too late. They didn't then apply for condemnation, and we went by ourselves to the labor court. Obviously, we proved discrimination. And Mrs. Else got 18,000 Rand. 18,000 Rand. We sued for 1.8 million Rand, and she got 18,000 Rand. So that just shows you that it's very, very difficult to prove damages, especially for an employee who's coming to a matter. In other words, she was never employed by the school. She was an applicant for employment. And the applicant for employment, it's very, very hard to prove discrimination, because not only do you have to prove it as a kind of a initial stage, you have to prove it that you would have been employed, and you would have been employed for a certain period of time. So if you can't prove that you would have been employed for a certain period of time, you only couldn't prove that you've been employed, well, they could have got rid of you in the next month. And that's what the judge said. 1 month into the matter, she could have been employed. So what's the salary for 1 month? 18,000 Rand. Okay, I'm granting you 18,000 Rand. And he found also that because she had bought a car, because she had to travel to another company and get a lower salary, that wasn't discrimination. There was no discrimination in that at all.
Have we got any other questions?
I do. I have a question about this notion of arbitrary grounds versus listed grounds. Andrew, what's your perspective on why is it so difficult to bring a claim under arbitrary grounds? I mean, is it that the courts aren't flexible enough? They are not being as thoughtful enough around the ways in which issues evolve, statuses evolve, discriminatory practices can change over time? I'm just a bit curious about, the ways in which
I don't know, Alice, are you looking at it from a kind of American point of view? Are you American at all?
Yes, I am.
Yeah, so
guilty as charged.
Yeah, but in America, it's a kind of a much more open system. Here, we've got listed grounds. Therefore, in America, it's a completely different thing. In America, the way that they run it is that they say that there aren't any listed grounds. There are some listed grounds, but they're either race or gender. I think it's only race and gender are listed grounds. So all the other grounds are seen to be discriminatory already. Whereas in South Africa, we've got listed grounds because they have been part of the way that people have been treated in this country. People have only been treated unfairly according to those grounds, according to the Constitution and the like. So we seem to be already listed grounds, and therefore the listed grounds are substantially defined. We've got, I think, 13 or 14 grounds. And if you can't fit into one of those grounds, well, the state is saying to you that in actual fact, you haven't really been discriminated against. And that's really scary for me, because I feel that it's very unfair, because if you do have one of the arbitrary grounds, how do you get into the system? By listing your case as if it is a listed ground. And I can see in the comments there, the 18,000 Rand, somebody said that doesn't cover the legal costs. Yeah, 18,000 actually only covered the advocate's fees for the day. That was the advocate's fees for the day. So I got nothing out of the matter. My client got nothing out of the matter. And the advocate got his 18,000 Rand. And that was the end of the matter. It just shows you that when you bring a case on unfair discrimination, you need to have a solid case. What's more is I believe that a case where you bring it with many employees, in other words, you can say that there were 10 women who were pregnant, who were discriminated against, and there were other women who were not. Right? In other words, only the pregnant women who were discriminated against, and you've got 10 of them. You've got a much more substantial case than if you bring one woman who is pregnant compared to other women who are pregnant or compared to other women, because her case just stands alone. I always believe that discrimination is like a strike. Discrimination must be more than one person. So if you want to say it's a class action, so as long as you've got two people, you can say those two people were discriminated against. And then you can look at maybe an arbitrary ground. But if one person comes to your office and they say that they're arbitrarily discriminated against, I don't think you've got a chance to bring a matter in the Labour Court or it's the CCMA.
And then just, oh, sorry, Alice, you can.
No, go ahead. Go ahead, Chantel.
Just the issue of proving damages in the Labour courts. I mean, they're really successful. What is your advice there on proving damages? I mean, do we have to go to the extent like you find with road accident fund claims where, you have a psychologist and a psychiatrist, and what do you advise?
Yeah, no, I definitely advise that you must get psychologists and psychiatrists involved and experts. Damages experts is incredibly important in these matters. I think that those, if you can get those people involved, 100%. But the other way to go about proving damages is to look at Rule 1810 of the Uniform Rules of Court. Rule 1810 of the Uniform Rules of Court sets out how you must prove your damages, and there's 10 points as to how to prove the damages. And a lot of people don't forget about Uniform Rules of Court and the like when they come to Labour Court because they believe that the Labour Court rules will help them. Labour Court and Labour Relations Act doesn't even mention damages. The important part is to look at the Uniform Rules of Court to prove the damages beyond a reasonable doubt. And damages are also must be proven as to what they relate to. Are they patrimonial? Are they not patrimonial? Are they physical? Are they mind-related? Are they, you need to say what you want to prove. You can't just prove damages and say, well, look, I suffered before, therefore, in the community, I was defamed, my reputation went down, I couldn't get a job anywhere else. You'd have to prove that you tried to get another job somewhere else and who didn't employ you because of your reputation, and that person didn't employ you because of your reputation. You'd actually have to prove cause and effect. And that's a very hard thing to prove when it comes to damages. So you have to list your damages. And I always believe also that damages should be listed as high as possible. In other words, if you're not looking for R1 million in damages, you're not looking for anything. So, and if you're looking for R1 million in damages, if you manage to get 200,000 Rand, you've probably done well.
Right. Okay. Sorry, Alice, you had a question there?
Yeah, but just to follow up on Andrew's last comment about listing damages as high as possible, it reminds me of that old saying, you shoot for the stars and pray that you hit a treetop. So I guess that's what we would be doing in terms of asking for R1 million and hoping or expecting to get a tad less. Yeah. But Andrew, I wanted to ask.
Sure.
Go ahead, Andrew.
So you can imagine in Labour Court, out of the 20 years, I think Labour Court's been around for 24 years, that there have been thousands of cases brought for damages, and only I think maybe 100 have succeeded. Actually, I can only find 18 that I've found that have succeeded. And the biggest case that I find is a case which is the guy asked for 500,000 Rand and he got 171,000 Rand. And his damages were for whistleblowing. Whistleblowing is a completely different kettle of fish. And I think that whistleblowing, there you can get damages. And even my case, which I did for Mr. Potgieter against Tabati Ferrochrome, which is actually the same company, Samancor, where we won outright. We only got his salary back. There was no damages. And he was there dismissed. He got eventually 18 months salary, and then he had a claim for another 34 months of salary, which is still going on. And now he's actually got a problem because he mitigates these damages. In other words, he found a job at another company. And the courts have found that mitigation of damages is the offense. So Solomon Holmes is actually the same company, and Mr. Anthony Solomon out actually for Mr. Potgieter until he didn't like me anymore, until we started losing the cases, until he didn't listen to my advice, when he should have accepted 6.2 million Rand, and he went for the stars, and he has got nothing. he's cases for 8.8 million rand. He wouldn't accept 6.2 million rand, and now he's only got his 18 months, which comes to 1.3 million rand. And he's fighting about 7 or 8 cases at the moment at the Labour Court, which he's losing with costs each time.
Andrew, when I listened to you talk about the cases before the Labour Court and the difficulty in proving damages and the limitations on the ways in which some discrimination suits can be brought forward, I just wondered, what's your perspective on what's going on in the Labour courts generally? Is it that the judges are particularly conservative or that the law is particularly limited? It just sounds to me that to have so many damage cases brought before the court and so few of them to be successful, that something may be out of kilter.
I think that our policy, our law allows for other things other than damages. And I think that that's what the labor law looks at, because the labor law looks at trying to correct the problem. In other words, when you bring a discrimination problem, how do you correct the problem? How do you get the problem corrected to be so that there is no discrimination? And they believe, the courts and the system that we've got believes that that is good enough, that you make the matter. So once there's no discrimination at the company, the policies change or they're forced to change their policies and get the matter right. That's all that is important. So when you get a case like the police case, the lady who was a police officer, which is very well known, I actually can't think of her name at the moment, but her case, she never challenged the policy itself. And had she challenged the policy, she should have won her case. But because she didn't change the policy, she couldn't prove discrimination itself. So that's another thing you need to do, is that you need to understand that you need to, if you want to get damages, you actually need to prove that the policy itself is inherently discriminatory. Then you'll get damages. But very few people can prove that. So if you can prove that the company's got a policy of only employing African people or only employing Indian people, then that's proving that the policy itself is inherently discriminatory. You'll get your damages. But if you cannot prove that, then rather stick to the law and rather get the law right. In other words, you bring a case of that pregnant people should be treated better. Well, then the company then treats people who are pregnant better. And that's the end of the case. There's no need for damages or the like, because now the law has changed. That person will then get their salary that they didn't get or the differentiation that they didn't get. But to get damages is another kettle of fish. So I think that the law as it stands and the judges as they apply it is fair in our system. And we've got a wide range of discrimination laws which cater for nearly every circumstances. Okay.
Okay, thank you.
Well, since there's no other questions, then I think we can close off this morning. Andrew, thank you very much for that informative talk. I think this has put a lot of perspective into what we've been talking about when we talk about the practicalities. So Alice, I'll be handing over to you just to close off.
Well, thank you. And just in closing, I want to again thank Andrew for taking the time to prepare this presentation, this very informative presentation, and to share it with us. I would like to put in a plug for the participants to give serious thought and perhaps a commitment to doing pro bono work, and particularly doing pro bono work representing people who are infected and affected by HIV/AIDS and TB, and those who are in need of legal representation in those contexts. So thank you for joining us. Please continue to be a part of these webinars, and please, everybody get vaccinated and stay safe.
Yeah, or you could lose your job.
Or yes, you could lose your job. And that's another lawsuit that will be that will be working their way through the system. Very, very.
Yeah, I actually gave a talk. I'm giving a talk on the 4th of next month about exactly that issue about vaccinations in the workplace. So if anybody wants to get on that talk, they can email me or they can phone me. And if anyone wants to get hold of me, I'll put my phone number in the side here, so that if anybody wants to get hold of me in any respect, they can phone me. You know, there's my number there, my cell phone number. I'm freely available anytime you want. I'll give you my email as well. So, you know, anytime people can call me and debate matters with me. It's nothing better than to debate matters. You know, that's the most important thing about law that we miss in this country, is that we have a legal fraternity which doesn't debate matters. We've got the advocates who debate matters amongst themselves, the judges who debate matters amongst them, but the lawyers are too shit scared, excuse my language, to debate matters. They don't come together, they don't talk to each other, they're always fighting issues. And as a lot of judges have said, and a lot of people have said, it's more important to try and settle a matter. So if you get a bad matter, don't always say that it is a bad matter. The other side might think you've got a brilliant matter. You phone the other side and you say to the other side, what about if we settle this matter? And don't raise your client's values too high, but tell them that, look, you know what, maybe you get 3-4 months out of this matter and maybe we can all go on with our lives. But if you don't have a good matter, don't bring it to court. Rather try and settle the matter, because settlement is a very important strategy. It's a very important answer to a lot of the problems.
Yeah, we can be far too litigious in terms of always wanting or thinking that we should get a day in court. Yeah. Especially
in South Africa. It's probably worse than anywhere else in the world trying to get to court. People believe that they've got a case and they will spend all their life savings and everything to get to court. And then when they don't win, they wonder what happened.
Right. No, well, thanks again, Andrew. And thank you, too, for being so available. I think a number of the folk who are participating are young professionals, new, just breaking into the practice of law. And it's great to know that a senior practitioner is willing to reach out and provide guidance and help. So thank you for that.
Yeah, I see that Paul has said that the court roll is clogged because of this. The labor court roll is clogged by about 3 to 4 years. So if you're trying to get a trial before court, because everybody else has brought their matter to court and they don't have prospects of success, you're waiting 3 to 4 years. I'm having a matter heard on the 8th of next month. The individual was dismissed in 2012. And the matter wasn't even delayed. We've just been kicked off the court roll 3 times. So we were in court in 2016. We were kicked out because there wasn't a judge available. We were kicked out in 2018 because there wasn't a judge available. And here we sit in 2021. And what's more is that ridiculous side. The other side has never, ever phoned me, have never dealt with me at all, have never, ever contacted me to try and settle the matter. And we've got a good case. So I don't know why. They agree that we've got a good case. So at least they could have phoned us and said, we only want in 12 months. So at least they could have phoned at the 2012 salary. So at least they could have phoned me and said to me, what about 3 months or the like? But, most people in labor law and in litigious operations in South Africa with an adversarial system never, ever want to talk to each other.
And there's a message from Wendy. Andrew is brilliant, so take advantage of his offer to pick his brain and debate with him.
Thanks, Wendy.
I think perhaps our next talk has to be on settlement discussions and how to facilitate that, because a lot of us are just geared to fight and draft pleadings and go crazy.
I think all lawyers need to be educated, even myself.
Great.
But I try and settle I settle 1 in 3 claims. I'd like to settle half my claims. I settle 1 in 3 claims.
All right, well, I'll be emailing the slides and then again, all the information that we've been collecting, case law, we've got policy, we've got legislation, that's all been put up on the probono.org website, and we'll be adding these as well. So if you're looking for references, please use the website. And then, yes, we'll be sending out invitations for our next webinar, which will probably be at the end of November. So look out for that. Thank you very much for joining us.
Thanks, everyone.
Thank you.